It's not uncommon for taxpayers who are considering ways to protect their assets or expand their portfolio to want to move assets offshore or to acquire offshore assets. But it's important that taxpayers who are U.S. persons to consider a few key facts. First, if you're a U.S. person, that's typically a U.S. citizen, lawful permanent resident, foreign national who meets a substantial presence test. The U.S. is still going to tax you on your worldwide income. Therefore, you still have to pay taxes in the US on the income you earned overseas. Another important fact is some people think moving the assets offshore means that the IRS can't find them, but hundreds of thousands of foreign financial institutions report US account holders for FATCA, which is the Foreign Account Tax Compliance Act. So chances are, even if the institution doesn't tell you, they're going to be reporting you to the US government. Third, by opening and foreign accounts, having foreign assets, you're going to significantly increase the complexity of your U.S. tax return. You have to report this income on your U.S. tax return. You may have various international reporting forms you have to file, such as the FBAR Form 8938, 3520, 5471. And finally, another key fact to consider is if you don't properly report the assets and the income on your return, you may be subject to fines and penalties, especially international reporting penalties. The penalties can be severe even if there's no unreported income. So these are important considerations to think about before moving assets offshore or acquiring foreign assets.